Let us discuss the next question now. This is also from 2024. As per the Article 368 of the Constitution, the Parliament may amend any provision of the Constitution by way of 1. Addition, 2. Variation, 3. Repeal. Select the correct answers using the code given below. Now, what does Article 368 contain? Article 368 has the provisions regarding the amendment of the Constitution. So the question is also saying that as per the Article 368 of the Constitution, the Parliament may amend any provision of the Constitution by way of what? How can the Parliament amend the Constitution? By way of what? Is it through addition? Is it through variation? Or is it through repeal? Or is it through all of this? Now, the constituent power, the power to make laws, also gives the Parliament the power to make changes to the laws to meet the changing times and nature of the society. The Parliament also has to make changes to the Constitution, amend the Constitution. And how can they amend the Constitution? Can they add something to the Constitution by changing the Constitution? Yes, that is addition. Can they vary some of the provisions? For example, to give an example, instead of 21 years for the voting age, it was reduced and changed to 18 years. So there is a provision regarding the voting, adult suffrage, but something was varied here, something was changed here. Can that be done? Yes, that can be done. Can something be repealed? Say some provisions of the Constitution are not relevant anymore. Can those provisions or articles can they be repealed? Yes, definitely. So when we say the power to amend, it is very holistic. It involves the power to add something, it involves the power to change something, and it also involves the power to repeal or remove something. That is what is the comprehensive term amendment mean. Now select the correct answer. What does amendment comprehensively cover? It covers all of this. So answer will be 1, 2 and 3. Now let us look at the bare act of the Constitution. If you look at Article 368 of the Constitution, the subheading says power of the Parliament to amend the Constitution and the procedure thereof. So it contains the power of the Parliament to amend and also the procedure to amendment. Clause 1 says, notwithstanding anything in this Constitution, the Parliament may exercise of its constituent power. Like I said, see, the Parliament has the power to make laws through the Constitution. So using the same powers to make the laws, the Parliament can now add something, vary something, or repeal something. So the bare act says, by exercising the constituent powers, amendment by the way of addition, variation, or repeal any provision of the Constitution in accordance with the procedure laid down in this article. So if you can see clearly, the words addition, variation, and repeal, they have been lifted from the bare act. That is why I suggest most of the times to my students to read the bare act at least once, so that you get habituated to the language of the Constitution. So the correct words are all of them, 1, 2 and 3. Answer is D. Let us discuss the next question. This is from the year 2023. In India, which of the following constitutional amendments was widely believed to be enacted to overcome the judicial interpretation of the fundamental rights? So the keyword is widely believed to be enacted to overcome the judicial interpretation of the fundamental rights. Amendment 1, Amendment 42, Amendment 44, and Amendment 86. Now, after the Constitution came into force, certain states tried to make certain reservations for certain class of backward classes. And Champakam Dorai went to Madras High Court, and finally the case went to the Supreme Court, and in the state of Madras versus Champakam Dorai case, famously known as the Champakam Dorai case, the court said that you cannot make provisions for giving some reservations to a particular class of people because it will amend and affect the articles 15 and 29. The court here went for the literal interpretation of the Constitution provision and said that the state government didn't have this power to provide reservations on the grounds of, say, religion, race, and caste. So in order to nullify this literal interpretation of the court, of the Supreme Court, the government made the First Amendment Act to the Constitution, and the very First Amendment Act in 1951, it added clause 4 to Article 15, which said that the government is now empowered to make any law for the upliftment of the socially and the educationally backward classes of citizens, or for the scheduled castes and scheduled tribes. So basically, the court went for literal interpretation which was there in the provision and said that the act of Madras government was wrong. So in order to nullify this act, the first amendment was made which added that the government is empowered to make laws for the upliftment of the socially and educationally backward classes of citizens and also the scheduled caste and scheduled tribes. Now this was the major act done by the government in order to overcome the judicial interpretation of the fundamental rights. So our answer would have been correct. But because it is choose any of the above which is correct, even if you look at the amendment 4284, even they to an extent affect the fundamental rights and they try to overcome the judicial interpretations of the Supreme Court. So you cannot say that this is the only amendment which will be the answer. So because this has multiple answers, UPSC dropped this question. So normal cases, because it said which is the widely believed provision which was enacted to overcome the judicial interpretation, the answer should have been A. But because it can lead to different perspectives and different debates, and you can get more than one answer as correct, and because we have to choose only one answer as correct, UPSC went for the safe route and chose to drop this question.